Hi guys, my name's Rion Norris. I'm a barrister here in New Zealand. On this channel, I'm going to be talking about common legal issues and problems and sharing some of my knowledge and experience. And my goal is to improve access to legal services in this country. With that being said, today I want to talk about limited license applications. So let's get straight into the video. So what is a limited license, first of all? Well, a limited license allows a disqualified or suspended driver to drive for a limited or specific purpose. Now, most commonly, that's to do with work, whether that's your job or your business being affected by your loss of license. But it can also be relevant for picking kids up from school or taking family members to important medical appointments, for example. So, are all suspended and disqualified drivers eligible to make an application? Well, the short answer to that is no, and it depends on things like what previous convictions you might have. Now, the rules around that are set out in the Land Transport Act. I'm not going to bore you with the relevant provisions, but if you check out in the link in the description below, there's a link to a free eligibility tool, which is on a separate website, which I'm also involved in, called pinklicense.co.nz. So how do you go about actually applying for a limited license? Well, you need to make an application to the district court. Now, the district court that you make that application to will depend upon whether you've been disqualified, in which case you make the application to the original court that disqualified you. On the other hand, if you were suspended, you make that application to your local district court. So what actually is an application? Well, it consists of an application notice, a draft court order, and also your affidavit evidence, which is basically a sworn statement setting out the relevant facts in support of your application. Now, as the applicant, you'll always have to make an affidavit or a statement. And also, anybody that's supporting your application will also have to put in affidavit evidence. Now, that might be your employer or a family member, for example. So what do you need to satisfy the court of in order for it to grant an order? Well, the court looks at whether you as the applicant have suffered extreme hardship or whether someone else has suffered undue hardship, be that an employer, a family member or whatever. Now, somewhat unhelpfully, the legislation doesn't actually set out what those terms mean or give a precise definition, but the cases have established that extreme hardship will be established where your job is at risk or your business is at risk of failing as a result of your loss of license. On the other hand, it is a lower hurdle to actually establish undue hardship to someone else. So that's worth bearing in mind when you're making your application. And it may be that you have suffered both extreme hardship and someone else has suffered undue hardship. So in the example of, let's take the example of an employer, and you're making your application on the basis that you'll suffer extreme hardship as a result of losing your job, but your employer will also suffer undue hardship because they've got to perhaps go to the time and expense of recruiting somebody to replace you. Perhaps they've got to re-roster some of your colleagues or pay overtime or additional hours to your colleagues to cover your duties. So your employer in that situation would put in an affidavit setting out all of those facts in order to establish that they have suffered undue hardship as a result of your loss of license. So your evidence needs to be really robust and really go to establishing the hardship that has been suffered by both you as the applicant and, in the example I've given, the employer. You also need to satisfy the court that granting an order won't be contrary to public safety. Now, that's going to mean different things depending on what the actual offence was that's led to your disqualification or suspension, and also what kinds of previous convictions you've got. Now, at the extreme end, if you've got a lot of previous convictions for similar offences, it may be necessary to go to lengths such as taking a defensive driving course in order to satisfy the court and evidence that you're not going to be a danger to public safety. At the other end, if it's your first offence, then you should be able to point out in your evidence what kind of things you're going to actually do in order to make sure that that offence doesn't happen again. And that may be as simple as giving some assurances that you're going to pay closer attention to speed limits or that kind of thing. Now, generally in relation to your application, it's really important that you engage early on with the police and discuss your application before you actually get to the point of filing it. Now, that's because the police are the other party to this application, and they can actually and do oppose applications. So what you can do is actually speak to the police prosecutor, and it may be that you can agree certain conditions so that the police don't oppose your application. Now, that can be helpful in a number of ways. Firstly, the court is more likely to be favourable to your application if it knows that the police aren't opposing it. But also, if you've got witnesses that you're bringing along to a hearing in order to support your application, if you agree beforehand with the police, you can actually reach agreement that those witnesses don't need to attend on the day of the hearing. So you don't need to inconvenience your witnesses. So in the example I've given, your employer, for example, would then not need to go to the hearing. But that's only possible if you've actually agreed that up front with the police and you've then notified the court of that agreement. So bear that in mind, that that's really useful. And of course, you don't want to find out that the police are going to oppose your application and the details of that actually in the hearing. You want to know about the types of issues that are going to arise before you actually file your application. So that gives you an opportunity to address that, whether that's including additional conditions on your limited license or whatever the case may be. It's also worth bearing in mind that even if the police oppose your application, ultimately it's down to the court to decide whether or not the application is granted. So it won't mean that your application is going to fail because the police oppose that application. It's really down to the judge on the day, and that's why, of course, it's important that you put the best evidence that you can into your application. And it's also relevant that if your application is unsuccessful, then you can't make a further application for 3 months. So it just underlines the point that it's really important to get it right first time round. How much does a limited license cost? You have to pay also a court application fee when you make that application, or when you file it, as it's called in legal jargon. Now, again, it will depend upon whether you were disqualified, in which case the application fee is $150, or if you were suspended, it's a $200 application fee, plus a $50 court sealing fee. And there is also a fee that you have to pay to NZTA, and that's $39.30. Remember, the court order is not the limited license. That's simply the authority or the permission that you take along together with filling out an application, which you send off to the NZTA, who will then consider that application, and if they're agreeable, they'll issue the limited license, which is your pink license. So how long does it take to get a limited license? Well, for court-ordered disqualifications, there's usually a 28-day stand-down period. Now, what that means is that the court can't make an order in respect of your limited license until at least 28 days have passed since the order disqualifying you. Now, it's important to realise that that doesn't mean that you can't prepare and file your application within the 28 days. It just means the court can't make an order until day 29. So don't waste that 28-day period. You can still get your application prepared and filed so that then you can get your hearing as soon as possible after the 28-day period has elapsed. But either way, it's going to take probably a week or two to get all of your evidence prepared and get it filed, particularly if you need to get affidavit evidence from an employer or a family member or from your accountant, for example. So just bear that in mind. So what can you expect at the hearing of your application? Well, on the day of the hearing, you should turn up in good time and you should wear court attire. Now, that doesn't necessarily mean that you have to be fully suited and booted, but you should wear as smart clothing as you've got and not turn up in jandals and shorts and a singlet or something like that. It's about presenting yourself in a respectable, courteous way so that the judge has a good impression of you. Now, you'll need to find your case on the listings for that day. Generally, these types of applications go into what are called the general list. So your application or your matter will be listed with a host of other matters on that day. So, for example, if the general list is at 10 a.m., there'll be a whole host of other matters which are also listed, and you'll need to sit patiently in the public gallery and wait for your matter to be called up. Now, you could be the first matter or you could be the last matter, so you could be in for a couple of hour wait depending on how busy the court is on that particular day. But when your case is called, you need to go forward and you need to answer any questions that the judge has for you, and obviously be as courteous and respectful as you can. And if you need to refer to your application, then ask the judge if you can just take a moment to check any of your answers or that kind of thing. And the judge will be perfectly happy for you to do that. Then hopefully the order is made and you'll have already provided a draft order as part of filing your application. Any amendments to that order will be made there and then. And then you'll need to go and see the registrar afterwards in order to get your court sealed copy of the order, which is basically the court stamp on your order. And you'll need that court stamped order for the next stage, which is making your actual application to NZTA for your pink license. So I've covered off what actually happens after you've obtained your court order and that you've made your application to NZTA, you've paid the relevant fees, and you get your pink license back. So what happens next? Well, it's obviously crucial that you drive in accordance with the conditions that have been set out by the court. Now, that will mean at all times that you're driving, having your limited license with you, and also a copy of the court order, and also anything else which has been confirmed by way of conditions. Now, a common condition is that you have a logbook which records all of your journeys. So make sure you've got that in the car and that's kept up to date, so that if you are stopped by police or traffic officer, then you have all the relevant information and you're not going to get into any difficulties around that. Okay, so that's about it for today. Hopefully that's been a useful summary of some of the issues involved in limited licenses. And if I can be of further help, then you can find me at thedisputelawyer.co.nz. And I've put a link in the description below to the website. And I've also put a link in the description below to pinklicense.co.nz.